Hi, Judge Griffen. How you doing?
Professor Chambers, I'm doing well. Good morning to you. How are you?
We're hanging in there. It's nice and warm, but that's all right. We're going to have a nice, fun conversation this morning. Let's hope. Well, I'm sure that we probably ought to go ahead and introduce ourselves. You want to go first?
Sure. My name is Wendell Griffen. I am a retired state court judge, trial court and appellate court judge, living in Little Rock, Arkansas. I am co-chair of the Samuel DeWitt Proctor Conference, and I am pastor of New Millenium Church in Little Rock, Arkansas. And I'm also a cultural competency consultant with my own firm titled Griffen Strategic Consulting here in Little Rock.
That's fabulous. I'm Hank Chambers, given name Henry Chambers, obviously. My folks would spin in their graves if they heard me introduce myself as Hank. But Henry Lawrence Chambers Jr., a law professor at the University of Richmond. I teach various courses regarding criminal law, voting rights, and do a lot of writing in constitutional law, including law and religion, and some other places. But a lot of work in this area, and I'm privileged and honored to be with you this morning. So, what do we think? Let's think about this. We're going to talk about the Religious Freedom Restoration Act, or RFRA. So, can you give us a little bit of a background on RFRA?
Yeah. You and I live in the world, the intersection of law and religion. And as you know, the Religious Freedom Reparations Act, or as we call it, RFRA, was passed in order to deal with the issue of how faithful people navigate the public sphere and at the same time feel free to do so without fear of being oppressed by politics or have their faith oppress politics. And that's the way I put it.
The fact is that the Religious Freedom Restoration Act is something that all Americans can support.
It was, as political things go, a wonderful compromise between those who believe that religion should be left alone, or those who believe that politics should be left alone, and those who believe that religious freedom should be able to operate unchecked, and those who believe that religious freedom should have some boundaries, otherwise it would turn into a license to discriminate. And so that's the way we look at it. Now, you amplify that because you work in the academy, and tell me where I missed.
Oh, I think you got it just right. Let me just add a little bit to it in terms of asking or thinking about why it was necessary, because I suspect that some folks listening to this would say, we don't understand. We already have a First Amendment. So why did you need religious freedom restoration? It sounds as though someone was jumping on top of it. And it's fair to say that there was a bit of disagreement about how protected religious exercise was.
3 years ago, Oregon v. Smith diminished America's longstanding commitment to the free exercise of religion. Since then, there have been dozens of cases in which it's been applied, and the citizen has lost in almost every case. Those whose religion forbids autopsies have been subjected to mandatory autopsies. Those who want churches close to where they live have seen churches zoned out of residential areas. Those who want the freedom to design their churches have seen local governments dictate the configuration of their buildings. Well, today's bill restores freedom of religion.
As the Vice President said, this act reverses the Supreme Court's decision, Employment Division against Smith, and reestablishes a standard that better protects all Americans of all faiths in the exercise of their religion, in a way that I am convinced is far more consistent with the intent of the founders of this nation than the Supreme Court decision. More than 50 cases have been decided against individuals making religious claims against government action since that decision was handed down. This act will help to reverse that trend by honoring the principle that our laws and institutions should not impede or hinder, but rather should protect and preserve fundamental religious liberties.
RFRA says that any law or regulation that substantially burdens one's exercise of free exercise rights, essentially, has to be justified under strict scrutiny, which is a concept coming out of the Constitution, which says, hey, if the state or local government or federal government is going to substantially burden one's exercise of free exercise rights, then that burdening has to be justified by compelling state interest and has to be drawn narrowly in order to only get at what the state has a right to regulate.
What this law basically says is that the government should be held to a very high level of proof before it interferes with someone's free exercise of religion. This judgment is shared by the people of the United States as well as by the Congress. We believe strongly that we can never be too vigilant in this work.
So we can see that means that I'm going to be able to engage in lots of free exercise and engage in it in a way that stops the state from telling me that I can't do it. And that's where you then get folks saying, hey, anytime I want to do something that relates to my religion, I should be able to do that unless the state has a fantastic reason to stop me. And that's where we then get the notion that all I need to do is say, this is my religion. And I'm not suggesting that people are being insincere, but all one has to say is, this is my religion, and doing this qualifies as freely exercising my religion. And that triggers RFRA. At least from the federal perspective.
What happened, Professor Chambers, after passage of RFRA?
Yeah, you had a lot of folks who looked at RFRA as, in some ways, a sword and in some ways a shield. Now, we of course want to be fair. We're both men of faith, so we don't want to view the use of RFRA as problematic automatically, but the notion that RFRA provided the opportunity to wear one's religious practices on one's sleeve and to exercise them in a maximalist fashion became important. So the idea that I needed to do something, that I needed to engage in religious activity, and no one could stop me, was the way that I think some organizations and some groups worked their way through the concept of RFRA. And as a consequence, you had folks who sort of maximized their ability to exercise their particular rights. And some of those ways butted up against discrimination laws. Right. So one of the situations we had, and it wasn't right after RFRA, but over time, we eventually got to the Hobby Lobby case, where you ended up having a for-profit corporation arguing that its free exercise rights were being violated by being required to provide some forms of what they called abortifacients through healthcare.
We granted certiorari to decide whether RFRA permits the government to demand that these closely held corporations and their owners provide health insurance coverage for methods of contraception that violate the owner's sincerely held religious beliefs.
And the argument was, well, my free exercise, my vision of the way that I have to engage in my religious obligations means that me, corporation, not really just individual, me, corporation, gets the right to make this determination. And RFRA says I'm allowed to do so. Right. That was sort of the maximalist vision. So I'll leave that as an example of a maximalist vision, but I bet you may well have a couple of thoughts on that as well.
We've got the situation of that Kentucky county clerk who was refusing to issue marriage licenses to same-sex couples because of her religious belief, the Kim Davis case. And that challenge, that tension between Kim Davis' assertion that, hey, as a devout follower of my religion, I ought not to have to do something, issue a marriage license to a same-sex couple if same-sex relationships violate my faith, just ran right up against everything that RFRA was trying to do. All of the tensions that surrounded RFRA seemed to come to bear.
The question of what the scope is and what it's supposed to cover is contested territory.
Yeah.
It's been contested territory since RFRA came out. We did not mention the one big, or I shouldn't say the one big case, but a big case out of Supreme Court, the City of Bernie versus Flores case, which limited RFRA's coverage.
Yeah.
And as the court said in City of Bernie, that Congress had overstepped its bounds when it said that cities and states were also limited under RFRA. Then we had some state RFRAs that were also passed over time, which got around the Bernie situation.
I think that brings us to where we are now. I call the state RFRAs, or what I call the mini RFRAs, have now sort of taken the field in a real sense, because state by state, they began to try to enact state versions of RFRA. And as a state court judge, I viewed that with some concern, because my history teaches me that state courts have been oftentimes the least reliable protectors of civil liberties. State legislatures have oftentimes been the most active infringers on civil liberties, because they legislate, criminalize stuff that would ordinarily be viewed as legitimate dissent or legitimate exercise of religion, and then the courts basically rubber stamp that because they defer state legislatures.
Yeah, you raise a really fascinating point, and that is, what is the full structure of how we regulate religion?
Yeah.
Because as you noted before, I think we have the Establishment Clause, we have the Free Exercise Clause in the First Amendment. So we have to make sure, in theory, that the government does not establish religion, does not prefer the religious over the non-religious, but we also want to make sure that people can freely exercise their religion, in theory, in as pluralistic a way as possible. Although we'll get into how pluralistic America has been in terms of allowing people who are on the outs to exercise their religions. Then we dip in with RFRA. Part of what's interesting, one of the things that I forgot in terms of mentioning Bernie, was the court's position in Bernie was that RFRA was too broad because it tried to protect things that weren't explicitly protected under the Free Exercise Clause. That is, the court said, it's one thing for Congress to protect the specific free exercise, but here Congress is saying you can't pass just regular laws that have an effect on people's ability to freely exercise. They said that's too broad a protection, because it's not like there are a whole lot of entities that are trying to stop people from exercising their religious rights. So it's really quite interesting that even in the wake of RFRA, the court's position was there are not a whole lot of folks out there, a whole lot of states and towns and counties out there that are trying to stop people from exercising their rights. So very interesting that states would step into the breach and say, oh, no, we're going to protect those rights that the the Supreme Court essentially said were not really being infringed in a large scale structural way. Do you think the court was being fair when they suggested that, or was there a rash of governmental entities trying to restrict people's free exercise of their religion?
Well, minority religions have always had the challenges, whether it's peyote use or marijuana by Rastafarians. Minority religions, whether you're Hindu or Muslim, minority religions have always had to struggle, as we know. And so I didn't, but to your point, I don't think there was a rash of activities to governmental actions oppressing religion. I think, and here my skepticism comes through. When the state RFRAs began, I began to become skeptical of them because I thought that we're not talking about religious freedom. I thought they were talking about religious chauvinism. What they wanted to do was basically create a safe space for majority religions to engage in hegemony and to use religion as a way for them to, with impunity, use power, seize power, political power, social power, cultural power, and control not only protection of their religion, but impose their worldview, social view on a society that's supposed to be pluralistic in terms of religious faith. And so my skepticism about RFRA, state RFRAs, began in earnest at that point, not because there was a big effort to suppress religious activity, but because, as I tell people, I've been Black too long. I remember when religion was used by white enslavers as a license to engage in slavery, because they said that by religion they could save the people they enslaved for the afterlife, and then use the fact that they were Christianizing religion as a way of saying we're doing a good for the society. And that's that skepticism that I bring to this whole conversation grabbed me by the brain when the state religious freedom exercise acts came out, and it has not let go. If anything, it continues to shake me, and I confess it. Now, and that, I think, is part of why we're seeing some civil rights groups backing away and saying, I don't know what I think about this RFRA thing. We don't have a question about religious freedom. We don't have a question about religious exercise. We don't have a question about religious liberty. But we worry about whether or not what was supposed to be a shield from discrimination has become a sword to discriminate.
Great point. Let me note, there is an irony there, because I suspect that for folks who don't know what you've laid out, their initial response would be, or their initial analysis would be, well, but Smith was about stopping a minority religion, or people exercising a minority religion, from engaging in ceremonial use of peyote. RFRA responded to that, so surely RFRA must have been about protecting religious minorities.
In 1990, the Supreme Court's decision in Employment Division v. Smith upheld the firing of 2 Native American employees for participating in ceremonial peyote smoking during personal time.
And as you noted, well, the term religious freedom sounds grand for everybody, but when there's hardcore protection for it, sometimes it can be used by other groups or by majority groups to, like you say, talk about religious chauvinism to get us to the point where I guess in some ways it's like discussing the war on Christmas, which it's odd to talk about it considering how much we celebrate and how much we structure the winter around a Christian vision of Christmas. Even though we call it the holiday season, we recognize that for many people, that's not at all what's going on. How should we sort of think about moving forward on issues along those lines? That is there a way to protect minority religions?
There is, but I think we have to be honest with ourselves. We cannot pretend that the ghost of Jerry Falwell doesn't exist. We can't pretend that the ghost that seized RFRA, and I shouldn't call it a ghost anymore because it's very much a substantive benefit. There are well-funded groups, the Alliance for Defending Freedom. I mean, these groups would have innocuous sounding names in the name of religion, whether it's the Beryl and Hobby Lobby decision or the response to the Obergefell decision that validated same-sex relationships and marriage. That well-funded group is not a ghost. It's not a specter. It is a juggernaut.
The passage of RFRA was meant to reinstate a broader protection of free exercise rights. It was not meant to erode civil rights under the guise of religious freedom. Importantly, it did not change the First Amendment's Establishment Clause, which ensures that government cannot elevate certain religious or moral beliefs above the law. No sooner than RFRA was enacted, floodgates began to open, and RFRA has since been used to legitimize housing discrimination against single mothers and minorities, shield church groups from paying child abuse victims, and impose extreme emotional harm on school children based on their gender identity.
It is operating in the name of religious liberty, name to religious freedom. So much so that we hear this now new talk about Christian nationalism as an excuse for religious freedom, which fits into my notion of religious hegemony or religious, I use the term, I called it chauvinism, but chauvinism may be too kind a term, as bad as it is.
So how do we think our way through the folks on both sides who do have religious support for their position? That is, we're not necessarily questioning, I don't think we're questioning the sincerity of folks who want to discriminate. That is, I don't question the sincerity of Hobby Lobby, but how do we deal with that, or how should we deal with that in our current, theoretically, religiously pluralistic society?
The way I have thought about it, Professor Chambers, is we have to, and here I'm concerned because we have to depend upon the lawyers and the judges to interpret this. We have to rethink what's thought of as narrowly infringing on exercise rights. Because the compelling interest side of the analysis, does the government have a compelling interest to regulate something? Governments are pretty good at fabricating compelling interests. I mean, the history of our war making shows that we don't have very much difficulty in manufacturing compelling interests. What I am worried about is rather than a clash of rights, there are often religious interests and secular interests on both sides that are involved in this I wish I could call it a conversation, but it's not a conversation. It's a clash. It's a confrontation. And we're seeing it worked out not only in our politics, but we're seeing it worked out in the way religious freedom is morphing into religious license to not only discriminate, but also religious excuses for conduct that can be anything ranging from oppressive to inconvenient. And simply because it's inconvenient doesn't mean it's infringing.
That's yeah. You raise a great point, and here obviously as lawyers we both look up and say, all right, we can talk a little bit of trash about lawyers, but hey, we're also going to give lawyers and certainly you judges their due. How do we think about the notion of a substantial burden on one's exercise of religion? Because that's what RFRA talks about. It talks about a substantial burden. Are there burdens that are light? And if they are relatively light, they're still a burden, but they're still relatively light. In that circumstance, RFRA should not even apply. Yeah. How do we think our way through the idea of what qualifies as a substantial burden versus a non-substantial burden? How do you think about that as a judge and lawyer?
Well, I think about, first of all, is what are the activities, what are the expressions that are allegedly infringed upon by the governmental measure that's being challenged? Is the freedom to worship, is the freedom to protest, is the freedom to believe, is the freedom to behave in a way consistent with one's faith, whatever that faith may be, being infringed upon? And if so, is that light? Is it a burden, or is it an infringement that is similar to that everybody else has to do? I mean, there are no burden-free lives. I know we like to have comfort, but the truth of the matter is, as I was a judge, I would remember myself, there are no burden-free lives. The notion of liberty itself requires responsibility, and the responsibility to include acceptance of differences. And that may be viewed as a burden in some respect, because in my perfect world, nobody would have a view different from mine, and everybody would agree with mine because I'm right. But the fact that I live in a world that's not that way doesn't mean that I am substantially burdened. The fact that you may have a different view, or that government may allow you to exercise that view differently, doesn't substantially burden mine. It simply means that I have to, as the young folks say, need to get a life. I cannot use the fact that I am inconvenienced by a different way that the government allows people to behave, or inconvenienced by a government protection, RFRA. Mere inconvenience by RFRA does not constitute, in my view, a substantial burden, because, as I used to tell people in jury duty is inconvenient. It is inconvenient. It is time consuming. It is also essential. And it is essential that we distinguish between what is inconvenient and what is oppressive. RFRA was designed to protect people from oppressive governmental measures that oppressed them, that prevented them from being free to live out their religions, not simply made their religion inconvenient. I'm not sure that my analysis has found very much support by the judges who write opinions on RFRA in the states and in the U.S. Supreme Court, however.
That's a good point. The issue of substantial burden versus inconvenience, it strikes me that if you have judges who are used to working in majority religions, they may be more willing to deem a burden to be substantial because they're familiar with that religion. Whereas if they're not familiar with a religion, they may have no idea how substantial a burden is, and that in and of itself can put a thumb on the scale in one direction or a thumb off the scale in another direction with respect to non-majority style religions, or I shouldn't say majority style, but religions that are not in the mainstream of thought, and whose practices are not necessarily in the mainstream of thought. Is there any way around that?
I don't know. What you've just now asked raises the question whether or not, and to what extent, our whole notion of RFRA has altered our idea about anti-discrimination. And I don't know how we get around that, because, as you know, I mean, you teach anti-discrimination law and you teach religious liberty. I mean, as you know, one of the areas of anti-discrimination law is the law to be free from discrimination based on your religion. But we're seeing people use RFRA as a license. And so I'm wondering, has RFRA altered how we look at anti-discrimination law? Because I don't know how we get around that. I mean, I've been wrestling in my head, honestly. How do we get around this tension? How do we reconcile it? And I haven't figured it out. It is a conundrum to me. And the other thing is, I don't know whether we have matured enough as a society to embrace a language that goes beyond tolerance to inclusion.
Yeah.
To inclusion. And I mean, I'm not talking about law here. I'm talking about life and community. Because we have anti-discrimination laws aimed at protecting people from being oppressed. And we have RFRA that's being used as a sword. And I don't know whether RFRA has become a way where we rethink this whole idea of anti-discrimination. I don't know.
What do we do in a situation where one's sincerely held religious beliefs suggest that they in fact are required to discriminate, inconsistent with civil rights laws? Do we just say, guess what? That necessarily, the application of the law, of the anti-discrimination law, can't possibly substantially burden your exercise of your religious rights? Or do we say, well, it's possible, and therefore RFRA as read ought to pop up, with our notion being the only time you can substantially burden those free exercise rights is if the government has a reason that passes strict scrutiny?
My own view?
Yeah.
I think we need to have a reality check and say a lot of what people are claiming as religious discrimination, however sincerely they proclaim it, I'm not questioning sincerity, is not substantial infringement. This is a Chicken Little argument. Chicken Little was sincere. Chicken Little really believed that the sky was falling. But the rest of the world looked up and the sky was still up there. And we don't say Chicken Little was insincere. We simply say, Chicken Little, you're mistaken. And I think we deal with it that way. My concern is there's too little of that kind of critique of the substantial infringement. There are two people are too often willing to jump to the notion of saying, hey, if there is any inconvenience, I call it inconvenience, they'll call it infringement, on their religious expression, RFRA is triggered, and the government now, they can't do it. Therefore, anti-discrimination laws can't work. Therefore, vaccination requirements can't work. And I guess my question to you is, if we do that as non-lawyers, as practitioners of our particular faith, what happens? I mean, the RFRA laws are there. People are going to bring the lawsuits. The judges and courts are going to decide them. What happens if enough people say, wait a minute, the judges and courts have gotten it messed up. The pendulum has swung far too far in favor of the so-called religious freedom advocates, so that what is supposed to be a free society for free thinkers, and I use that term in the most broad sense, has become a society of the religious hegemonists, the religious majoritarians, because that's what I'm seeing. And I worry about that. I don't know how we address that. How would you suggest this ought to be dealt with?
Wow. I don't know. One reason why I say I don't know is that I have tended to care more about the question of sincerity than a lot of folks. That is, courts tend to not want to talk about sincerity or about the question of the substantiality of the burden, although I think they're more willing to talk about the substantial nature of the burden than they are about sincerity. But my take has always been that claims that religion requires that one do certain things are less convincing than most. And I tend to be willing to ask some additional questions. For example, I recognize that in our faith, we're supposed to keep the Sabbath holy. I get that. But there's a lot of play in the joints regarding what qualifies as keeping the Sabbath holy.
I like that.
And the notion that if I choose to do one thing, then I have made a decision to not keep the Sabbath holy, and I'll have to live with that. But if the government makes me do it, then that substantially burdens my free exercise. That's one where I think courts ought to have a right to ask the question, hey, is this a substantial burden? And are you serious that you believe that your religion requires that you do this particular thing? And I take that to be the case as we expanded out the Hobby Lobby. Here's part of the issue that is a plus and a minus, particularly for the nature of our discussion regarding minority religions, and that is courts will ask whether the person believes that their religion requires something, not whether the religion requires it.
Yeah.
So now the individual is the locus of deciding a religious question, which in some ways is very positive, because if we said, no, we're going to locate the decision regarding religious doctrine in the religion itself, then that would give a huge benefit to established religions that we all know about. But on the flip side, if we put it at the personal level, then that makes the person, arguably elevates whatever idiosyncrasies the person has in terms of religion, and says, we as a society have to say to that person, you may not necessarily be required to do what the rest of us do, because in your mind, you now think that following this law of general applicability substantially burdens your religion, and we as a society are not willing to ask about sincerity, generally speaking. That structure is one that's really hard, because as soon as I say, let's come down and ask the sincerity question, I'm now also asking the sincerity question about religions that are outside of the mainstream, or religions that may be in the mainstream but have heterodox views. And that gets us to what happens when you have a Black religious history that has heterodox views.
Yeah.
And surely we're not saying, let's ask harder questions about Black religious heterodox views than about those that are inside of the mainstream. So you've asked a question that I don't know how to deal with, but I do think it requires more discussion than folks just saying RFRA solves it all.
Right. 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 And that raises another question. I want to toss it to you. I hope it's not unfair. Are we teasing out the notion of conscientious objector?
Yeah, it's a great question, because we don't have to go back all that far. Obviously, God rest his soul for Jerry Falwell, but also God rest his soul for Muhammad Ali.
Yeah.
Where his notion of conscientious objection was not even outside of the mainstream.
No.
Yet and still, it required that some people think really hard about issues on which it shouldn't be that difficult, particularly when they say, well, he was a boxer. He hit people, so why can't he go off and kill people? Those are two completely different things from a religious perspective.
This is an important case because it poises a famous athlete, the heavyweight or ex-heavyweight champion of the world, against the United States Selective Service System, which treated him, we say, unfairly. He had just announced at that time that he was a so-called Black Muslim. On 14 February 66, he wrote a letter to his local draft board, alleging facts which he claims entitled him under the law to several lower classifications, including that of the conscientious objector. At that time, the Justice Department had a conscientious objector section, and all letters were written by a man by the name of T. Oscar Smith, who was in charge of the section. And this letter was written back, signed by T. Oscar Smith. And then he comes to this conclusion. It is therefore our conclusion that the registrar claimed objections to participation in war insofar as they are based upon the teachings of the Nation of Islam, rest on grounds which are primarily political and racial.
So in some ways, the inability to understand fairly obvious religious issues when they come out of the mouths of Black people, it is one of those limitations and one of those real issues. How we deal with that is arguably not even a question of free exercise. It's a problem of the American problem of dealing with race.
We never get far away from that, do we?
We certainly talked about the religious mainstream and non, but I do want to put a slightly finer point on that, is to say, we're both in faith situations that people would consider to be mainstream.
Yeah.
But I think it's fair to say that we probably have visions of conscience as Black men that are tied to our religion that may not necessarily qualify as being in the mainstream.
Yeah.
So the way that we think about taking care of the poor, I think we talked a little bit about those folks who, off camera, talked a little bit about those folks who left water and food for folks who may have crossed the border unlawfully.
Right.
And how that may well be a manifestation of religion. What we need is, like you say, we need the will. We need the will to treat everybody as a full person and a full citizen who is entitled to their rights of conscience and therefore their rights of free exercise in a society that says you may have to temper your full free exercise in order to guarantee that we have a pluralistic, religiously pluralistic society.
Yeah.
And that's hard. And it takes time. But it may well require that we start with that will that you noted, and then we can work on ourselves that much more. And I know some people would say, no, we already have plenty of religious pluralism. Well, yeah, it's easy for me to say. I can go to church and freely exercise whenever I want. Hey, I don't have to work on my Sabbath because we've already deemed my Sabbath to generally be a day of rest.
Right.
But what about those other folks?
We've already taken 2 weeks off for my religious holiday in the wintertime, but we don't take it off for Ramadan.
Right.
Or for Yom Kippur. And so we have to think about that and begin to ask, how do we make a more perfect union unless we're willing to acknowledge that as much as we celebrate the Constitution, there are some imperfections that were baked into it and will not be corrected unless we say, wait a minute, we got to take this recipe and not try to cover up the batter, but from it, create a new batter and bake a new cake. Still calling it the kitchen in the United States.
Yes, indeed.
Still calling the kitchen in the United States, but we're going to have a better cake.
I hear you.
I hope we can do that. I don't know, as Dr. King says, I may not get there with you, but I believe we will get. I dare speak of hope because I refuse to believe in either futility or everlasting frustration. I believe that somehow we can create a future together concerning religious liberty that rewards faithfulness without fatalism. Professor Chambers, this has been a good conversation. I've enjoyed it. Let me ask you one final question and share with me your thoughts. Given all we've talked about, what is your hope for the future of religious liberty?
Yeah. I'm going to duck back into the Supreme Court and the First Amendment. My hope is that we get serious about free exercise and our pluralistic society. That is, the court continues to talk about free exercise and looks like it's expanding free exercise, but they don't seem to be expanding it with an eye toward guaranteeing a religious plurality in this country or religious pluralism in this country. I think if they focus on the concept of free exercise as the way to get to religious pluralism, then we'll get to a better place. That's my hope. That's my hope and maybe my prayer. How about your hope and maybe your prayer?
I think you've said it, that we will work intentionally to talk about religious liberty and free exercise in a wider, deeper way that invites us into community as opposed to pulls us away from community and chauvinism. I believe we can do it if the will is there. I hope we have the will, and I hope the Supreme Court will give us the freedom to find a way.
Amen to that.
From our lips to God's ear. However she may hear us.
I hope I have a direct line. I don't know.
And by whatever name God may be answering.
Yeah. This has been great fun.
Been fun. Let's stay in touch.
Will do. Will do.